I sometimes wonder what is the lowest moment in American religious liberty history. Was it the 1777 flogging of the Baptist preacher by the sheriff in Caroline County, Virginia, for singing a hymn in public without a license? Was it Missouri Governor Lilburn Boggs' 1838 executive order commanding the state militia that Mormons must be treated as enemies and must be exterminated or driven from the state? Was it Ulysses S. Grant's 1862 General Order Number 11, removing all Jews from Kentucky and Mississippi and Tennessee for alleged war profiteering? Was it President Grant's decision to play the anti-Catholic card by proposing the Blaine Amendment in order to restore scandal-ridden Republicans to power in the 1876 election? Or was it the 1922 Oregon ballot initiative promoted by the Ku Klux Klan and the Masons that effectively sought to shut down Catholic schools? I want to suggest today that we add another candidate to this list, the HHS contraceptive abortifacient mandate under the Affordable Care Act, and I want to explain what's at stake in the Little Sisters of the Poor case and other cases now before the United States Supreme Court. It is the spear point of a much larger agenda. First, a little history about this mandate. On November 23 in 2009, Senator Barbara Mikulski proposed an amendment to the Affordable Care Act, which essentially said that employers offering health coverage must provide coverage at no cost to the employee for women's preventive care and screenings. That was the term, women's preventive care and screenings. She spoke twice on the floor of the Senate regarding what her amendment addressed, and she made clear that it was about, quote, guaranteeing women access to those critical preventive services to combat their number one killers, and end of quote, like screenings of cancer, diabetes, heart disease, vascular disease, and so on. She not once mentioned contraceptives or abortifacients. Even with this clarification, Representative Stupak withheld his vote until President Obama firmly committed to issuing an executive order that, quote, maintained current Hyde Amendment restrictions, end of quote, on the federal funding, against the federal funding of abortion. So on March 23, 2010, President Obama signed the Affordable Care Act into law, including the Mikulski Amendment, and including a provision of the act that says that the act, quote, shall be construed to required, nothing in the act shall be construed to require a qualified health plan to provide coverage for abortion services. That's what the statute says. Well, on August 1, 2011, a year and 6 months later, the Health Resources and Services Administration issued an amended interim final regulation that defined the preventive services in the Mikulski Amendment as including what it euphemistically called contraceptive services. The so-called contraceptive services included not only contraceptives, but abortion-inducing drugs and devices, sterilization, and related counseling. So I call it the CASC mandate. This regulation directed employers that if you have a non-grandfathered plan, it must include CASC services, and the fine for non-compliance is fatal. $36,500 per employee per year. So the lawsuits came. 104 ministries and religious employers like Hobby Lobby filed lawsuits to try to defend their religious liberty. More than any moment in American history, more lawsuits than any moment in American history of people of faith and organizations of faith trying to vindicate their religious freedom. After the complaints from the faith community, the government exempted what it called religious employers from the CASC mandate. Now, consistent with the president's view that religious liberty is cabined to houses of worship, this exemption only applied to congregations and denominations and religious orders and their unincorporated ministries. It excluded the Little Sisters of the Poor, nursing homes, Colorado Christian University, Catholic hospitals, Hobby Lobby, and lots of others. After further complaint from the faith community, the government provided a so-called accommodation for non-exempt ministries with self-funded plans. While purporting to address their religious liberty concerns through a specially worded form one could send to one's third-party administrator, This form effectively hijacked the employer's plan and required the TPA, as now acting as the employer's surrogate, to provide free cask services. Well, then came June 30, 2014, a good day. The United States Supreme Court found that the Religious Freedom Restoration Act, RFRA, created an exemption from the mandate for Hobby Lobby and other similar employers. This was a victory for closely held for-profit businesses operating in accordance with religious values. The problem is, and I suspect most of you don't know, is that 1 year later, 1 year and 1 month later, the administration issued a regulation that stole this victory from Hobby Lobby. It made Hobby Lobby and other for-profit businesses eligible employers, just like the Little Sisters of the Poor, and put them in the same class as they are. Now, it's important to understand that the imposition of the cask mandate against conscientiously opposed employers is built on deceptive promises, a deceptive premise, deceptive language, and deceptive arguments. Let me give an example of the deceptive promises, 2 examples. Remember the executive order? It promised no federal funds for abortion. When the employer sends that Form 700 to the third-party administrator, and the TPA now has to provide the cash services, who do you think pays the TPA for doing that? It's government money laundered through the exchanges. That is how that's paid, a direct violation of the executive order. What about Senator Mikulski's promise that her amendment was not about abortion services? She took the floor of the Senate when she was proposing it on December 1, 2009, and promised that the amendment did not include abortion services. Let me quote her. "Alert, alert, alert. We have just been informed that a shrill advocacy group is spreading lies about this amendment. They are saying that because it's prevention, it includes abortion services. There are no abortion services included in the Mikulski amendment," she told her fellow senators. The deceptive premise, and now listen closely to this. The fundamental deceptive premise of the cask mandate is this. The government said it needed the mandate so that poor women could access cask services beyond their reach. But the mandate is imposed upon employers, and employers only give health care to full-time employees, and full-time employees, folks, can afford the $4 a month it costs at Walmart to buy a birth control pill. Thus, in most instances, this morally compromising cask mandate, creating all this fuss, accomplished little more than forcing Christian employers to aid and abet that which they consider sinful. What about deceptive language? Take the word contraceptive. Contraceptive prevents conception. But in Affordable Care Act speak, contraceptives also destroy fertilized eggs. This deceit extends to insurance policies. Insurance policies in your organization state that they, quote, cover contraceptives while excluding, quote, abortion, end of quote. But contraceptives in government speaks adopted by your insurance company includes abortifacients. This is why so many ministries and so many religious employers, business employers, opposed to abortion don't realize that they're paying premiums today on policies that cover abortifacients. Another example of deceptive language. Everyone on the planet agrees that if there's any group that's religious, it's the Little Sisters of the Poor, but not the government. They're an eligible organization, not eligible for the religious exemption. Deceptive argument. We just filed a brief with the United States Supreme Court in the Little Sisters case on behalf of the Catholic Benefits Association. That brief details the false arguments made by Department of Justice attorneys at every single circuit court of the United States that ruled against this freedom. And the error in their argument was adopted by those courts, but now that it's reached the Supreme Court, the Solicitor General has admitted that those statements were false. Now, he doesn't use that language, but he says that there is a hijack of the employer plan that would burden the religious exercise. Now, how will the Little Sisters of the Poor case fare at the Supreme Court? With the passing of Justice Scalia, I fear they will lose their issue before the Supreme Court. They will lose either with a 4-4 tie, that means the adverse circuit court decisions below will stand, or they'll lose on a 5-3 majority opinion because Justice Kennedy joins the dissenters in Hobby Lobby. Now, what's at stake? On a political level, what's at stake is whether rights trumpeted by sexual activists should always trump religious liberty rights. That's precisely the proposition that Kai Feldblum from Georgetown University Law School proposed before President Obama nominated her and placed her on the EOC as a commissioner of the EOC. On a moral level, what's at stake is whether a regulation built upon deceptive promises and a deceptive premise and a deceptive argument and without foundation in the language of a statute or the legislative history withstands constitutional scrutiny, and whether people of faith can be forced to provide services that they find to be sinful. On a legal level, what's at stake is whether RFRA's role in protecting religious liberty will be hugely diminished. In several regards. First, with regard to a burden, what's going on in the circuit court decisions is that the government courts are willingly replacing the moral analysis of all of these conscientious Christian ministries with their own moral analysis. There also, as part of this, is that there's the issue of whether the United States Supreme Court is going to eviscerate what's called the compelling state interest test by declaring that the government's interest in forcing nuns and others to include caste services in their plan is a government interest of the highest order, even though they exempted plans under their grandfather exemption that covered at the time somewhere between 50 and 70 million employees. How can it be an interest of the highest order? Now, ladies and gentlemen, this caste mandate is the camel's nose under the tent. What's next? Already within the Affordable Care Act is also something called the clinical trial mandate. And the clinical trial mandate requires employers to cover clinical trials whenever the FDA approves them. And the FDA has approved at least 2 trials that involve embryonic stem cell protocols, and at least 7 that involves the use of fetal tissue harvested from aborted children. That's in your plans today. No one has gotten exemption from that. On September 8th, the government proposed a new regulation that is just waiting to be made final when the president decides to declare it final. That regulation interpreting the prohibition on sexual discrimination in the Affordable Care Act interprets it to mean that the act also mandates gender assignment services. Think facial reconstruction for Bruce Jenner. It mandates surgical abortion, and it mandates same-sex partner coverage. If RFRA doesn't protect conscientious employers from the caste mandate, how will it protect them from these? On the broadest level of civil society, the forthcoming adverse decision, I fear, in the Little Sisters of the Poor case, will strike a blow at a number of matters regarding religious freedom. Now, one of the handouts I've given you today is this one entitled Why Religious Freedom Matters. And I would urge you to take a close look, and we can discuss it if you wish during the question and answer period, at items 5 through 10, because each of those important reasons of why religious freedom are important to our constitutional order and the underlying moral assumptions of that constitutional order will be struck lower, not down altogether, but lower by that decision that I fear is coming. Now, allow me to conclude on a cautiously optimistic note. While there may be an adverse decision forthcoming in the Little Sisters of the Poor case, the battle will not be over. This fight for freedom of conscience will not be over at that time. My legal team has, through the Catholic Benefits Association, acquired injunctive relief for some 700 Catholic employers. We think we can continue to protect them, and we're putting together plans to do that. And Jim Mischel and Paul Sherry and I have just formed the Christian Employers Alliance that will similarly serve, we hope, evangelical Protestant employers. And we'll be talking more about that tomorrow afternoon at 4:45 in the Constellation Room. Thank you so much.